Board of Commissioners, is that correct?
Yes, Madam Chair.
Are you a commissioner?
I am not. I'm the county attorney
Okay,
for
thank
Gwinnett
you.
County. Thank you. Good afternoon again, Madam Chair and members of the committee. As I said, my name is Mike Ludwiczak, and I'm the county attorney for Gwinnett County. I want to thank you and Leader Efstration for the opportunity to speak today regarding this bill and to share the concerns of Gwinnett County. As you may already know, with almost 1 million residents and close to 9% of the state's population, Gwinnett is the second largest service provider in the state of Georgia, second only to the state of Georgia. These services are critically dependent on the county's ability to plan accurately and to maintain adequate revenues to fund these services. As the governing authority of the county, the Board of Commissioners has the responsibility to represent the interests of all its residents, both in the unincorporated and incorporated areas. Part of this responsibility is to provide information to facilitate well-informed decisions concerning legislation such as this, which will necessarily affect the delivery of services and the means to pay for these services for all of Gwinnett's residents. And so I want to extend the Board of Commissioners' appreciation as well. Among these concerns, as been stated, is the loss of revenue to Gwinnett, which we have estimated using fiscal year 2023 data to be a minimum of $9.1 million annually. Revenue loss which can be recouped by increasing taxes and other services, fees, or reducing service levels. I caution that this is an estimate only, as we have not had the opportunity to obtain a fiscal impact study. Perhaps even more concerning, as has been mentioned, will be the forced and premature renegotiation of the existing SDS for Gwinnett and its 16 cities. Extensive negotiations in 2020 resulted in an efficient service delivery model which serves all of Gwinnett's residents. This comprehensive strategy, as reflected in over 800 pages of detailed agreements, was approved by the Community Affairs Department in 2020, with the next update not being due until February of 2029. The incorporation of a 17th city will necessarily trigger an earlier review and renegotiation and result in changes to service costs. As part of this negotiation process, and as acknowledged in the private study supporting Mulberry, it will necessarily be required to enter into agreements with Gwinnett or other entities to provide services at costs that are yet to be determined. In fact, we suspect that the future cost of services may be substantially more than the estimated cost of services in the private study. I say this in part because the cost estimates in the private study were based on fiscal year 2022 numbers. The study itself cautioned readers that these numbers may not be reliable, quote, as fiscal year 2022 immediately followed the state's emergence from the COVID pandemic. It may not have necessarily been a typical year for most of the comparable cities. Given the unprecedented rate of inflation that we're all familiar with that has occurred over the past year, and that the future cost of services will ultimately be determined by agreements yet to be negotiated, the cost estimates in the private study can't be relied upon with any degree of certainty. In light of this concern, the prudent course of action for you to take would be to follow the customary two-session process for the incorporation of new cities, which would at least allow for your consideration of normalized fiscal year 2023 service cost numbers. Now, I know that the proposed city has been compared several times to Peachtree Corners. I'll discuss just one revenue source, occupation taxes, to show why this comparison ultimately fails. The private study states that Mulberry will be, quote, primarily a city of homeowners occupying single-family detached housing. Non-residential property will make up less than 5% of its total tax base, the smallest percentage of any city in Gwinnett. This contrasted residential Mulberry with, quote, commercially developed Peachtree Corners, which in fiscal year 2022 brought in almost $4 million in occupation taxes. By comparison, the private study cautiously states we believe it is possible that Mulberry could generate occupational taxes of roughly $1.05 million. This is about a quarter of what Peachtree Corners generated in 2022 occupation taxes. Even more concerning is that the county's estimate, using normalized fiscal year 2023 numbers, is less than half of this amount. This is just one example, and there are others, of why Mulberry cannot be compared to Peachtree Corners. In addition to these financial concerns, Gwinnett also has several legal concerns related to this legislation. It purports to create a so-called city light, one limited to providing only 3 services, and is prohibited from collecting property taxes to fund these services. The legislation provides that these restrictions may only be removed by way of another voter referendum. Put simply, these restrictions are legally unenforceable, as stated by this body's Office of Legislative Counsel in 2015, by the Senate Incorporation Study Committee in same year, and by the Carl Vinson Institute when it reviewed Peachtree Corners Charter in 2017. The Constitution expressly prohibits the General Assembly from limiting any such powers or services except by way of a general law that would apply statewide to all cities. These experts have all concluded that city light charter provisions are unenforceable. The import of this is that regardless of this legislation's stated restrictions on services and property taxes, if Mulberry is incorporated, it will immediately have full legal authority to provide all services authorized by law, not just the 3 that are called out, to impose property taxes and utility franchise fees, and to do so without a voter referendum. This is why in 2015, the Senate Study Committee recommended prohibiting the city light concept from being included in future legislation. It also recommended, quote, that language be inserted into charters containing a millage cap that clarifies that the caps can indeed be increased by a city council through its home rule powers and without voter approval. It's why in 2018, this body amended the charter of Peachtree Corners to remove similar unenforceable restrictions on services. And finally, it is why legislation has been introduced in this body to prohibit the creation of city lights. If Peachtree Corners is going to be held up as an exemplar for the incorporation of Mulberry, then as recommended by the Senate Study Committee and as recently legislated by this body for Peachtree Corners, these unenforceable provisions should first be amended and clarified. They should make absolutely clear to referendum voters that Mulberry will immediately have full legal authority to provide all services and impose property taxes, utility franchise fees without a voter referendum. This is Gwinnett County's request of you. It is also concerning that this legislation provides that if Mulberry is incorporated, Gwinnett will be prohibited from modifying zoning during the 2-year transition period, effectively enacting a moratorium on zoning until the city can assume responsibility. These immediate restrictions, which provide that they conflict with state law, which provides that counties continue to provide services to a new city during the transition period unless the city and the county agree otherwise. Because of all of this, Mulberry could immediately face the costly challenge of defending a moratorium in court. These are costs that were not considered in the private study. In addition, it does not appear that the new city meets the legal density requirements for a new city. The private study, which provided such an extensive analysis of land use within the proposed city, failed entirely to address this threshold density requirement for incorporation under state law. As noted earlier, Peachtree Corners has been cited as an exemplar for the successful incorporation of a city in Gwinnett. However, if you're to truly follow the same process, it would necessarily involve a careful, deliberate planning process that occurred over a 2-year period prior to legislation being enacted. There was a fiscal study for Peachtree Corners, which was made publicly available in March of 2010. Legislation was not introduced until the following year. Regarding this process, the private study itself references a 2020 infographic prepared by the House Budget and Research Office that summarizes this process. The House infographic states the legislative sponsor files the bill, beginning a 2-session review process. The committee will study the proposed city over the interim and vote on the legislation during the 2nd session after its introduction. And this, in addition to the clarifying changes to the legislation, that's the other request of the Board of Commissioners, that you follow the customary deliberate process the same process that you followed for Peachtree Corners. Allow the time necessary for the careful study and thoughtful deliberation that the proposed incorporation of what would immediately become the largest city in Gwinnett in terms of land area and the second largest city in terms of population surely deserves. This would allow Gwinnett the time to obtain a fiscal impact study by a Georgia Public University partner, a study which the infographic notes takes 6 months or more to complete, and that has been our experience, so that all Gwinnett residents, and particularly those potential residents of Mulberry, will have a full and complete understanding of how this new city would impact them. These residents deserve no less. And on behalf of the Gwinnett County Board of Commissioners, I want to thank you again for this opportunity.